I don't entirely agree with Title IX and some of the things that it did to athletics, but in general, it tried to protect the rights and the ability and the opportunity for young men and young women to take part in athletics. And now it seems that President Joe Biden, on one of his first executive orders, has decided to destroy female athletics. I thought we'd talk about that with Mark Chenoweth, who's the executive director of the new Civil Liberties Alliance, unlike the ACLU, and former chief of staff to Congressman Mike Pompeo, who I'm a big fan of as well. Mark, welcome back to the program.
Nice to be with you, Lars. How are you today?
I'm not too bad, but am I overstating it when we say that by telling young female athletes you may have to compete against biological males, that Joe Biden may have just sounded the death knell for female athletics? Not all of it, but much of it, by saying all of these young ladies have to compete against young men, and they're not going to win that contest.
Well, it's not just a matter of winning a contest. It's taking away college scholarships as well and all of the economic ramifications that go with that. Title IX was put into effect in order to ensure that there would be equal opportunities for female athletes, and this executive order will have the effect of undoing much of the good that Title IX has done.
I mean, if anything, Mark, I've been surprised at the lack of outcry, because I figured when these changes started to happen, and we've been reporting on this show for years, that when you saw track and field athletes, where young biological males who identify as women beating young women routinely, I said, somewhere out there are moms and dads and grandfathers and grandmothers who are saying, how come my son or daughter, grandson or granddaughter has been out there training for years, and now she's put in a contest in which she has a genetic deficit, if you will, where she can't compete on a level playing field?
Well, that's right. It's important to understand that the executive order itself, although it would have this effect, the executive order does not have the force of law. What the executive order does is it gives instructions to parts of the executive branch, like the Department of Education, for example, and instructs them to bring lawsuits against school districts that don't buckle under and don't comply with the administration's interpretation of the law. But the underlying law itself has not changed. And in fact, the Biden administration's interpretation of that law is very contentious and has not been settled by the Supreme Court. So it's not as though school districts don't have a choice here. They don't have to go along with this controversial interpretation of Title IX, which, after all, is not the interpretation that has been in effect for the vast majority of the time since 1972.
Mark, what I look for is the de facto change. So let me explain it this way. If somebody says, well, we haven't actually changed the rules, you can still do whatever you want, I say, yeah, except that the school district many school districts get as much as 10% of their budget from the federal government. If they're effectively told, you don't go along with this, not only are you going to get sued, and that's going to be ugly, but the implicit threat that if you're not going with the program, some of that federal money may be at risk as well, which suggests to me that some school districts will just say, rather than spend a lot of money on lawyers, rather than try to fight Washington, D.C., let's just cave in and go with what they've told us to do in the executive order, even if it's not legal.
You're absolutely right that will happen in some cases, and we've seen that at the college level as well. When Vice President Biden led the charge on Title IX against colleges, he wanted to make sure that the protections for people accused of sexual harassment or other Title IX violations on campus didn't have due process protections, and that was also put into place by a dear colleague letter from the Department of Education that did not have the force of law. But just as you say, hundreds of colleges went along with that for fear of being sued, for fear of losing federal funding. Now, if a school district actually loses federal funding over something like this, they can turn around and defend against that lawsuit or sue the government themselves, because it isn't lawful to suspend federal funds on this basis. But how many school districts will be willing to put up the fight? That's the question.
Well, and how many years is it going to take? So say you've got a fight. You've lost federal funding. You go to court. It finally wends its way all the way up to the U.S. Supreme Court, and maybe 4 or 5 years from now, after you've gone through all the lower courts, you get a decision that restores the funding you've been missing for the last several years. They may not be willing to take that kind of punishment in the short run, right?
You're absolutely right. You could try to get a preliminary injunction to keep the status quo in terms of funding, but you might not win that either. So you're absolutely right that there's risk involved there. And one wonders if there's risk on the other side as well. If the school districts just buckle under and go along with the policies, will there be lawsuits brought by parents and athletes against these changes that sort of balance the calculation of risk on the part of the school district when it comes to incurring litigation costs? Certainly organizations like the New Civil Liberties Alliance are interested in defending Title IX and the civil rights of students against this overreaching executive action by the Biden administration.
You know, Mark, today I was watching on Twitter, and there was a post up there that really, I thought the picture said it all. It was out of Texas. It involved wrestling, and believe it or not, there's women's wrestling and men's wrestling. And there was a young lady who was clearly a young lady, and there was a young man who was clearly a young man. But the young man had the young lady in a real control hold. You know, they were down wrestling, and she was clearly losing the match. And it was clear that his physical structure was allowing him to control that match. And I looked at that picture, and I thought that picture pretty well says it all. And I'm just wondering, when the people, the parents, the coaches, all the other people who are watching these matches see this kind of, and I think it's ugly to say, we're going to make you compete against a young man because he says he identifies as a woman, and you see that happening in front of you. I would think that even if you didn't have a daughter in the match, you'd say, that doesn't look right. That doesn't look like fair competition. And I'm kind of stunned that there hasn't been more outward objection to this, and especially by those parents who have daughters who are probably going to lose those scholarships. And there's no way 5 years from now for a court decision to, the scholarship you would have had to go to college, you didn't put your life on hold, so now you've already finished college, and they'll just call it moot, as they have with other issues like this.
It's definitely a good chance that that'll happen, Lars. That particularly as regards any particular athlete and a scholarship, you're absolutely right that by the time it wends its way through the court, it could be too late for that student to compete for that scholarship, which is one of the reasons why folks need to take a stand and need to try to get the preliminary injunctions and things like that to keep the status quo the way it is, rather than allow the executive order to affect the way the Department of Education is dispensing federal funding.
Absolutely. Mark Chenoweth. Mark, thanks very much.